All right. Hello, everyone. My name is Sarah. I am going to be acting as a moderator during this webinar. I wanted to start off by welcoming all of you to the webinar, Enforcing a Parenting Plan During the Pandemic. We are very excited to have attorney Elizabeth Gregory with us today. She is going to be sharing a lot of her insights and sharing a lot of information about parenting plans and sort of how they worked within the pandemic. And at the end, you will all have an opportunity to ask a few questions. So at this point, I'm going to go ahead and hand it over to her and she can go ahead and get started.
All right. Hi, Sarah. Hi, everyone else. Thank you so much. Like Sarah said, my name is Elizabeth Gregory. I'm a partner here at the Johnson Law Group. And today I am excited to bring you Enforcing a Parenting Plan During the Pandemic. So without further ado, let me first start the slideshow and share my screen. All right, Sarah, can you come back on and let me know if you can see my screen that I'm sharing?
Yep, it's looking good.
Okay, cool, awesome. All right, so enforcing a parenting plan during the pandemic. This isn't so much an issue now that we are over a year into the pandemic, and a lot of parents are figuring out how to negotiate and navigate the COVID restrictions and how that could potentially change a parenting plan, and how they want to work with the other parent regarding agreeing on the COVID precautions that they're going to be taking. At the beginning of the pandemic, like last March 2020, through the summer, this was, we had a huge influx of people calling to inquire regarding how to navigate their parenting plans given the COVID restrictions and stay-at-home orders. As well as people who would call asking for advice regarding another parent, their co-parent, who is preventing them from seeing their child and providing the reason of the COVID pandemic. We still are seeing a little bit of this, and we wanted to discuss this topic because not only to help with the current pandemic, but we don't know what's in store for the future. And it's always good to know how to enforce a parenting plan, whether it is COVID related or whether it's just a parent who's not following the parenting plan and you are someone who wants to enforce the parenting plan. So this can be advice. This can be a presentation that you can utilize not only during COVID times, but tuck it in your back pocket and pull it out if there's a scenario that's similar in the future when you might need to enforce a parenting plan. Also, this is not legal advice. Attendance at this program does not create an attorney-client relationship, although we thank you for attending and listening to the presentation. All right, so we have two common situations. Situation A is when one parent says, the other parent isn't taking the necessary COVID precautions, so I don't want my child going over there. I'm concerned for the child's safety. This is the parent who sees the other parent perhaps not following CDC guidelines, maybe not wearing a mask when it's recommended that you're supposed to, not following the stay-at-home orders when there were stay-at-home orders, that type of thing. So that's our scenario A on the one hand. And then we have the flip side, scenario B. We have someone who calls and says the other parent won't exchange the child as required by the parenting plan because he or she thinks I'm not following the COVID precautions. This is essentially the other parent refusing to effectuate the parenting time exchange, refusing to allow the other parent to have their court-ordered parenting time. So I'm going to be discussing both of these, and we'll start with situation A. So essentially, situation A, when one parent says the other isn't following the COVID precautions, I don't want to exchange the child, I'm concerned for the child's safety. Essentially, this parent wants to know, when can I legally not follow the parenting plan? The parenting plan says exchange the child. I don't want to because I think that the other party is not being safe, not putting the child's best interest first. I want to ensure the child does not get COVID. That is very logical and an understandable position to take. So when can I not follow the parenting plan? Failing to follow the parenting plan by not allowing the other parent to exercise their parenting time is called withholding the child. So the question is, when can you legally withhold the child? The only time that you can legally withhold the child is after filing an emergency motion to restrict parenting time pursuant to CRS 129 section 4. I have the legal citation in there in case you want to look up that statute on your own. But for our purposes, you don't have to know exactly what that statute means. When you file this emergency motion to restrict parenting time, you have to show in the motion, in the petition that you file with the court, that parenting time with the other parent places the child in imminent physical or emotional danger. All right, so that is the threshold you have to meet: imminent physical or emotional danger. This is a very high threshold, and we are going to discuss that on the next slide. Does failing to follow COVID guidelines put the child in imminent physical or emotional danger? No. Every court that I was in front of that we attempted this argument, the court said no. The evidence required is an expert medical opinion that failing to follow COVID guidelines puts the child in imminent physical or emotional danger, meaning the child will surely contract COVID, surely become extremely sick, and have the potential, of extreme consequences due to that sickness based on the parent not following COVID guidelines. The CDC didn't even have that much, still doesn't have that much assurance or tested, verified knowledge of what happens when you don't follow the guidelines. The science has shown trends, and we can see those trends, but there is nothing for sure. People contract COVID and they have no symptoms. They're asymptomatic. People contract COVID and they are very mildly symptomatic. It isn't clear the rate that kids contract COVID versus adults contracting COVID. The courts do not and did not have enough information to go off of. It was not per se danger to not follow CDC guidelines. So what is the takeaway? If not following COVID guidelines does not place the child in imminent physical or emotional danger, what are we saying? The takeaway is you have to follow the parenting plan, even if you don't like how the other parent is acting regarding the COVID precautions. The court is going to deny the a motion, emergency motion to restrict parenting time. At least every court that I was in front of did. I'm sure there are exceptions because there's always exceptions to the rule, but the important thing is to remember that imminent physical or emotional danger. That is the threshold, and that is difficult. So let's talk about situation B. This is the situation where the other parent is preventing me from having parenting time because they don't want to follow the parenting plan. They don't think that I'm doing a good enough job with the COVID precautions. So how can I make the other parent follow the parenting plan? You file a motion concerning parenting time disputes pursuant to 1410-129.5. This is the statute that allows a motion to be filed when the other parent isn't following the parenting plan. Now, we'll go into this next slide so that I can explain a little bit about this. This is the motion that says the other parent is not complying with a parenting time order or schedule. This does not include failing to follow decision-making. The decision-making orders, decision-making split, the joint decision-making, or whatever the decision-making order says. This is only for the parenting time schedule itself. The motion that you file needs to include your request for the possible sanctions or remedies that you want the court to impose. And we'll discuss those on the next slide because there's a lot of them. There's a laundry list of things that you can ask the court to order as far as sanctions or remedies against the other party. This motion is also considered a forthwith or emergency-like type of motion. It's not as emergent as the emergency motion to restrict parenting time that has to be heard within 14 days. This one has to be ruled upon within 35 days of filing, which is a lot faster than most motions are ruled upon. So this is considered an expedited motion. When the court rules upon this motion, the court can do one of three things. It can outright deny the motion if the allegations are inadequate. That means that the pleading just simply didn't state that the other parent violated the parenting plan, or it said there was a violation of decision-making when that's not what this motion governs. The court can set the matter for hearing as expeditiously as possible, or the court can require the parties to attend mediation within 63 days. So whether we're setting the hearing as quickly as possible or we're requiring mediation within 63 days, those are both considered expedited timeframes. Although I understand the legal term and legal definition of expedited or quickly often differs from the general public's concept and understanding of what quickly means. Court time is a lot slower than regular time. So keep that in mind, take that into consideration when you read the words expedited or forthwith. All right, so many options for remedies. All right, this is a summary of the approximately 11 different types of remedies. I combined some of them because the language is just so similar. So what can you ask the court for? You file your motion concerning parenting time disputes, and you have to include your request for a remedy. So what do you want? What do you want the court to order? You can ask that the court add additional terms or modify a previous parenting time order, the order that was violated by the other parent. You can ask the court to change it. You can ask the court to add terms, delete terms, or completely change it in the best interest of the child. And that's something that I guess I did write it at the bottom. The best interest of the child standard, that is always something to keep in mind. You want to argue to the court that the additional terms or modification or changes, that those are in the child's best interest. You can ask that the court require the other parent or both of you to attend parenting education classes. I would suggest that these education classes specifically address the issue that you are alleging is wrong with the other parent's conduct. So this means you're going to have to do some research. You're going to want to Google the available parenting education classes that are, well, right now available online. I'm not sure if there are any that are available in person yet. I don't think we're back to in-person education classes. But there are a lot of different types of education classes. So asking the court to order the other party to take an education class, that is a remedy that you can request that shows you're wanting to still effectuate the relationship between the child and the other parent, which is very important to the court. And it's also showing that you're invested and that you did your research, which means you're responsible and you've really thought these things through, which is also something that the court deems to be very important. You can also ask the court require family counseling. This is not so applicable for a violation of a parenting plan due to COVID reasons. But if the violation is directly related to something that could be remedied through family counseling, that is something that you can request of the court as well. You can also request the court order makeup parenting time. This has to be a very specific request. You must request like or the same type of parenting time that you lost. Or if you're not requesting the same type or kind of parenting time that you were prevented from having, you have to have a good argument for why you're not asking for that same type of parenting time. So for example, if you were prevented from having holiday parenting time, then it would be appropriate to request makeup holiday parenting time. Or if you lost, a Thursday, Friday, it would be appropriate to request makeup Thursday, Friday. The court should order that the makeup parenting time occur within the next 6 months, unless it's a specific request for something like you were prevented from having Thanksgiving last year, so you want to make sure that you have Thanksgiving for the next 2 years to make up for that, because you didn't have Thanksgiving for 2 years in a row. So that would be an exception that the court would make, but you want to try to, like I said, request that the makeup parenting time be the same or similar in kind and duration to what you were prevented from having. I mean, obviously, if you were prevented from having, four of your weekends, it would be unrealistic to ask for the entire summer. You want to make sure that your request is reasonable to the court. Otherwise, the court is not going to grant it. You can also ask the court, find the violating party is in contempt and impose a jail sentence. This is an issue of, can you ask for it? Yes. Should you ask for it? Probably not. I would only ask for this in a very, very egregious circumstance. Because asking the court to throw your child's other parent in jail doesn't look very good. So even though you can ask for it, I don't recommend it. There's a couple other remedies or sanctions that fall under this category as well. One of them is imposing a civil fine of not more than $100 per violation, per occasion of violation. And the other one is simply imposing a fine, or no, it's posting a bond. Monetary consequences don't look very good to the court unless it's something super egregious. And I cannot think of a time where I have had a case where the violation was egregious enough where I thought, in my professional opinion, it was appropriate to ask for any of these things. You can. I don't recommend it. Let me know if you'd like to discuss that. Maybe you can change my mind. The next one, schedule a hearing for modification of existing order. So this kind of ties in with that first one where you're asking to add additional terms or modify the previous parenting time order. If it's a minor modification, sometimes the court will do that without having an additional hearing. Meaning the court would do that after the hearing on the motion concerning parenting time disputes. If the court feels that more evidence is necessary to determine what parenting schedule is in the best interest of the child, the court may schedule another hearing to address the modification of the previous parenting time order. So that is an option as well. And then the last one is a catch-all. Any other order that promotes the best interests of the child. I usually use this catch-all to request a child and family investigator if my client feels that that's necessary for the case, if that is something that we have discussed, because it can be a remedy if we think it's in the best, if we think that it promotes the best interest of the child, then it fits in there. So that is that's the request that we make most often that fits into that category that isn't found in any of the other remedy provisions. And off the top of my head, I can't think of any others. All right, but what is the best remedy? If the court finds that the other parent violated the parenting plan, the court shall order the violating parent to pay your attorney's fees, court costs, and expenses. It is important, and this is why it is in capital letters, the court shall order the violating parent. Now, this first needs, in order to get your attorney's fees, you first have to go to a hearing and the judge has to find that the parenting plan was violated. Okay, so if you reach an agreement at mediation and the agreement includes all of the things that you wanted, such as the makeup parenting time, maybe you wanted a modification of the parenting plan, and these are the things that you agreed upon at mediation, there's been no finding. So the other parent isn't going to be required to pay your attorney's fees. I find this to be somewhat problematic sometimes, because it really entices people to want to go to hearing so that they can get their attorney's fees paid for. However, going to hearing is extremely costly in both the emotional sense and monetary sense. And a lot of times we can achieve our clients' goals by attending mediation, and it's a lot less costly in both of those senses, emotionally and monetarily, to reach an agreement during mediation that reaches the client's goals. Also, if the other party knows that this provision exists, if they have an attorney, or if they are savvy enough to know of this, we can often reach an agreement at mediation for partial attorney's fees. I have had that happen before. So this is my favorite motion. Anytime we have someone call and ask the question, you know, I want to modify the parenting plan. This is what I want to modify it to. Well, okay, why do you want to modify? Well, the other parent isn't following it. Okay, so we're not going to do a motion to modify. We're going to do a motion concerning parenting time disputes, because in the remedies, we can ask for a modification, we can ask for a CFI, and if the court finds that the other parent violated the parenting plan, you get your attorney's fees paid for. So we're kind of killing 2 or 3 birds with one stone, right? So I am a very big fan of this motion because of this attorney's fees provision, excuse me, and because of the versatility with the remedies available. So as I was saying from at the beginning of the presentation, this is not only something to keep in mind for the COVID-related parenting plan violations, but also just violations of the parenting plan in general. If there is a violation and one of those remedies that we discussed appeals to you, especially the makeup parenting time. I mean, if the other parent is preventing you from having parenting time, like, we want to get makeup parenting time. That relationship between you and your child is extremely important. It's in their best interest to have as much parenting time with you as possible. The lack of ability to effectuate the love and relationship between you and the child by the other parent, that's something that a court is not going to stand for. So this would be the motion that we could discuss. Final thoughts. Follow the parenting plan. If you don't follow the parenting plan, it's very likely that the other party will file a motion concerning parenting time disputes against you, and you'll have to pay their attorney's fees. So follow the parenting plan. Are there any questions?
So anyone that has questions, there's a little chat box. You should see it on the right-hand side of your screen, I believe. You can go ahead and type your questions into that, and I will read the questions, so that way you remain anonymous. Your identity and your questions, they will be totally anonymous. If you do have questions, but you don't feel comfortable asking them right now, you will all be receiving a follow-up email after this webinar, and you can feel free to reply to us. Our email address is on there, so you can feel free to reply to that. You can also email info@johnsonlgroup.com, and we can definitely answer any questions that you have. And I would also encourage everyone to follow us on social media. We're really getting started with these webinars and everything. This is Liz's second webinar. She has another one next week, also about parenting plans and summer vacation. So you can check out our social media. The links to register are on there. And you can also see the links in the follow-up email that you have coming your way, I guess, tomorrow. We do have one question. How does a court deem what is a violation and an applicable remedy?
Yeah, that's a really good question. So first thing that the court's going to do is look at the order. The existing order, the most recent order in the case, the court is going to look at that order, and then the court is going to compare the order with the conduct that has been alleged at the hearing. So if the order says that the parenting time exchange is to occur on Friday nights at 5 o'clock, and the other parent fails to make the parenting time exchange on Friday nights at 5 o'clock and instead makes it on Saturday morning, and it's not something that you agreed to, that's a violation. It's a violation of the parenting plan. Is one enough? I think is going to be maybe a follow-up question. Maybe, and it depends. Given the scenario that I just discussed, if those are the only facts, it was one time, the other parent failed to drop the kid off on Friday at 5, and instead it was Saturday at 8, and it only happened one time, I would say no. I would say cost benefit analysis is, if everything else is going fine and this was only one time, is it worth your emotional energy and the cost of filing a motion for the remedy of only one time? Probably not. However, if it's consistent, if this has been going on for 3-4 weeks, 2 months, yeah, I would say that is significant. Let's say that you're supposed to have spring break this year, and the other parent took the child out of town for spring break instead. That's a violation. And then what would the appropriate remedy be? In that scenario, make up parenting time. Unless there are other things that are causing issues or that are unclear in the parenting plan. Like, let's say, okay, the Friday at 5 exchange doesn't actually work anymore. Okay, so let's change that, but then let's add another overnight somewhere else for you so that you're not having your parenting time decreased. Same thing with the what did I say? Spring vacation, spring break. Let's say that the opposing party wants spring break every year, and you're kind of like, you couldn't really care about spring break. Like, okay, so maybe let's add another weekend or another week onto your summer vacation parenting time. Or let's add, maybe you want Thanksgiving every year, and the opposing party would agree to that. Making those changes to decrease the likelihood of violations is something that we want to discuss, and something that the court wants to do. The court wants to make a parenting plan that is functional and works for the parents. So if the violations are occurring because it simply doesn't work with the parent's schedule, then if that is something as the aggrieved parent that you want to change, then that's something we could propose. That is something that would be easy for the court to implement. But if you don't want to change the parenting plan, we're not going to ask to change the parenting plan if that's not what you want. So definitely the makeup parenting time is going to be the most utilized remedy. And then the attorney's fees, because Section 4 of that statute says that the court shall award the attorney's fees. So that's something that you can absolutely every time expect us to argue.
Thank you, Liz.
Yeah.
So I'll wait a little bit longer, see if any other questions come in. I feel like you answered a lot of questions in that one explanation, so thank you very much for that.
Yeah.
But as I mentioned, if anyone has any questions after this, feel free to email us. We'll definitely get back to you. We're also happy to talk if you have any other questions, concerns, anything like that. Our website even has a little chat box, so you can actually talk to someone from our website as well if you need. So I'm not seeing any more questions coming in. Liz, thank you so much for taking time out of your day to share all of your knowledge with us.
Yeah,
and
absolutely.
Thank you, everyone, for attending. And I hope to see you at the webinar next week.
Thank you, Sarah.
Thank you.
Bye.